Good morning, everybody. Thanks for waking up early. I'm Jameel, Jaffer. I'm the director of the Knight Institute here at Columbia. Whether you're here in person or watching online, we're very glad to have you. Those of you who have been part of the Knight Institute's community for the past few years already know our obsession with the question of how new technology is shaping or distorting public discourse. This is a topic that we have engaged many times from many different angles through research as well as litigation. This symposium, which is the capstone of a year-long partnership with Professor Arvind Narayanan, builds on our past work. Over the next day and a half, we're hoping to demystify recommendation algorithms, ask what their implications might be for public discourse and for society more broadly, and consider how regulatory or other interventions might help us harness the benefits of algorithmic amplification and mitigate its costs. For all of us at the Knight Institute, it has been an incredible privilege to work with Professor Narayanan on this project. We were thrilled when he agreed to come to the Knight Institute because we already knew his reputation as a brilliant, creative, and collaborative scholar. What we didn't fully appreciate about him until more recently is that he is also an extraordinary teacher, generous, patient, and amazingly adept at distilling technical concepts into language that even lawyers can understand. It's been great for us to have a chance to learn from him. I want to thank a few others as well. An event like this requires a lot of planning. The Knight Institute's research, communications, and administrative teams have been working very hard on this symposium for many weeks. They're amazing, and we're going to acknowledge them individually later today. I do want to take this opportunity to specifically acknowledge Katie Glenn Bass, our research director, who oversees all of our research initiatives and has been Professor Narayanan's close collaborator on every aspect of this particular project. That the project has drawn such broad interest and from so many different communities and disciplines is a testament to Katie's intellectual curiosity and her vision. Thanks to Arvind and Katie, we have a very rich program ahead of us. There is really no one more qualified to get us started this morning than Dr. Alondra Nelson, who I will introduce now. Dr. Nelson is the Harold F. Linder Professor at the Institute for Advanced Study in Princeton and a distinguished senior fellow at the Center for American Progress. Previously, she was the 14th president and CEO of the Social Science Research Council. She was also professor of sociology and the inaugural dean of social science here at Columbia. Her books include The Social Life of DNA, Race, Reparations, and Reconciliation After the Genome, and Body and Soul, the Black Panther Party and Fight Against Medical Discrimination. Very few people have thought as deeply and as productively as Dr. Nelson has about the implications of new technology for our democracy and our society. Until very recently, she served as Deputy Assistant to President Biden and Acting Director of the White House Office of Science and Technology Policy. In that role, she oversaw the development of a blueprint for an AI Bill of Rights, a prescient, inspiring, and necessary document that will shape conversations about automated systems for many years to come. What kind of society could we have if all innovation began with ethical forethought? Is one of the questions the document poses. And it's, of course, one of the questions we'll engage through this symposium. We're incredibly lucky to have Dr. Nelson with us this morning. Please join me in welcoming her.
Thank you so much. Good morning, everyone. It's really great to be back at Columbia, where I spent a decade on the faculty here. And Jameel, thank you for the introduction, and thank you for your leadership. I mean, when I was still on the faculty here, the center was just a proposal, and now it is an incredible, thriving place. Part of that is made manifest by the presence of all of you here this morning on a Friday morning, very early, both online and here in the audience. And so much of that owes to Jameel and his leadership and vision and the incredible team that he was able to bring to the center. So thank you all. And thank you also, Arvind, for your leadership here and your vision. It's been so thrilling to see. And as somebody who thinks about research infrastructures and research communities, like what you've built around algorithmic amplification has been inspiring for me to reflect on, and it's kind of what I'll mostly talk about this morning. So this morning I'm going to speak about kind of research and researcher journeys, their unexpected paths through and around challenges, especially things like data to study algorithmic amplification, and their critical importance for society. So we live in a time of overlapping challenges. The historian Adam Tooze, who's here on the Columbia faculty, calls this a polycrisis. And for him, the polycrisis is economics, politics, geopolitics, and the natural environment blowing back at us, and that's quoting Adam. He takes up the term polycrisis following from Edgar Morin and Brigitte Kern, who coined the term in the late 1960s, the late 1990s, and then 1996 book, and published in French, Terre Patrie, and then published in English in 1999 as Homeland Earth, the Manifesto for the New Millennium. Polycrisis was then later used by Jean-Claude Juncker, then president of the European Commission, in a 2016 speech about the overlapping impact of financial, environmental, and political crises of the time from the perspective of the EU, it's important to say. There's kind of perspectival bit that's important here. And it was taken up by a thematic. So Candace, I'm going to give this a whirl. There we are, okay. Thank you. As a thematic this year, in January of this year at the World Economic Forum, and which defined the polycrisis as the fact, as quote, present and future risks that can also interact with each other to form a cluster of related global risks with compounding effects, such that the overall impact exceeds the sum of each part. So Adam Tooze cites the most recent polycrisis, like is emerging kind of in 2008 with the financial crisis of that time, the beginning of Russian aggression against Georgia and other countries, the growing context and public awareness of the climate crisis, zoonotic migration from animal reservoirs to humans, including swine flu, and more recently SARS-CoV-2. In the World Economic Forum slide, it's much more, it uses this kind of swirls and nodes that are familiar to some of us from social networking maps to represent the devastating imagery of crisis, a social network mapping of collapsed supply chains, natural disasters, biodiversity loss, instability of the global financial system, and more. So I wanted to show this morning just to point your attention to the upper left, because that's where the technology is, and I think many of us who are in this space today are here because we understand that all of these things, and whole or part, are sort of undergirded by technological processes. And so I found it a bit, just shocking, actually, that digital inequality, digital power concentration that both enables and disenables so much of all of these other things is sort of not even a primary node in the sort of size and importance that we would understand from a social networking mapping. So in the upper left is this category of factors. The smaller in the legend of the network map, as I said, and therefore seemingly less nodal or central are these than the other factors, are a few things about the social implications of politics and technologies. Digital inequality, the breakdown of critical information infrastructure, digital power concentration, adverse outcomes of frontier technologies, widespread cybercrime and cybersecurity, and I'm just reading actually from the slide itself. So these are all quite familiar. As I said, we here in this room and online appreciate that these factors undergird all other polycrises. And here I would zoom in, on that upper left and think about that as what we might think about as the digital polycrisis. That is maybe two-part. That is the technological mediation of all other facets of the polycrisis, both enabling them, as I said, and making them both possible and not possible, and also attending in particular to crises that at least would include digital inequality, the consolidation of power and resources, a multinational technology industry, social and political tumult, caused in whole or in part by the disruption of new and emerging technologies. To this, of course, we must add the erosion of democracy, surveillance capitalism, the agnotology of so-called frontier technologies, which I'll say a bit more about, and the concomitant rise of responsive research, which is what I want to talk more about. So our responsive research journeys have brought many of us to the work of doing research in the eye, in the very sort of middle of crisis conditions that we could have hardly imagined, and that we try desperately to understand as they move all around us, and as we do research in the midst of all of this dynamism. The recent researcher journey has included an ongoing pandemic during which all of us here were impacted, during which some of us here lost loved ones. From within that experience of sorrow and those stressors, we also experienced an extraordinary outpouring of researchers and research across fields and methods who sought to describe and help us understand this terrible moment that devastated Black, brown, and poor communities in particular in its wake, invoking Christina Sharp. That same impulse has led many of us to research journeys here today as a direct response to the erosion of democracy enabled and exacerbated by algorithmic amplification, to the creation of social instability and the sowing of mistrust and division by the work of social media platforms, even as these same platforms enable voice and new networks for organizing and community at their best. These are conditions now accompanied by the scale and velocity of advanced artificial intelligence. Several years ago, when I led the Social Science Research Council, the organization served as an administrative home for a first-of-its-kind project to make social media data available to researchers with Facebook, now Meta. The project never quite delivered on its promise, although it's ongoing, and there's large new data sets released just this week. But as a research community, we had to start somewhere, and what we knew about what we needed for responsive research from within and about the digital polycrisis remains. That we could begin to apprehend and perhaps mitigate these overlapping challenges with resources and practices, including the following: algorithmic auditing, risk assessment, access to data for a wide range of researchers in government and journalism and industry that could offer some insight into platforms and platform algorithms and how they work to create social conditions, how they work to consolidate pathways for power and influence, and how they build social choice architectures. Doing this for the sake of more transparency, better accountability, explainability, privacy, and security as the ideal hope of this responsive research. For the most, none of these conditions have come to pass in a robust and egalitarian way, and so we're still seeking the conditions that we need to study the research and to, in fact, operationalize the norms, the practices that we know could help us understand algorithmic amplification in this moment. There's legislation such as the Algorithmic Accountability Act introduced in 2022, bicameral legislation by Senators Ron Wyden and Cory Booker and Representative Yvette Clarke that asks for researcher access to social media data as part of the legislation, should it come to pass. And recently, the enacted EU law, the Digital Services Act, promises to make data access for researchers a reality as it becomes implemented. So Edgar Morin and Anne Kern, who coined the term polycrisis, argue that the complexity of the polycrisis, its uncertainty and ambiguity can be a good thing, can be, as in their words, sources of creativity, learning, and transformation. One must add, of course, that this is only true for those of us on this planet in conditions of incredible privilege. For too many more, uncertainty and ambiguity is both quotidian and catastrophic. But thinking of that, of glimmers of creativity and of learning, I want to return, as I wrap up here, to the researcher journey and the research journey. So back to the SSRC, when it became clear that the promised data from Facebook would not come to pass in the way it had been promised, for a range of legitimate and somewhat questionable reasons, we as an organization continue to fund heterodox research on social media and tech platforms with the insistence that we could still know some things. And so yet here we are, and here you all are today, doing the work under less than optimal conditions, refusing to accept that this incredibly powerful form of sociality, the platform, cannot be known in part without donor data, and finding a way to derive keen insights from the data that is available, be that experiential, ethnographic, theoretical, or numerical. finding a way to use new resources, new methods, orthogonal perspectives, and committing to research and knowledge at a moment when we're being confronted with a kind of algorithmic agnotology. Agnotology, the politics of ignorance, that in the literature, the STS literature comes out of the space of big pharma and of large tobacco companies and the like. I think it's not surprising that I think we're having to think about this in the space of big tech. So this politics of ignorance, of deliberate ignorance, that is sometimes the flip side of the uncertainty and ambiguity that Moran and Kern find so generative. Finding a way through this agnotology, as we are being told that technical choices being made by industry in advanced artificial intelligence present us with a technical world, an algorithmic world that is unknowable, that is forever inexplicable. And moreover, that the path of this unknowable, inexplicable research is all but preordained. It is because of the incredible body of work created by many of you and your papers today that we have a window, a kind of moment of opportunity, I think, of optimism and opening, that even as these newest technologies, many of them now widely in the public sphere, and so now fomenting an important public conversation about what to do about algorithmic amplification, again, bring us back to the fundamental requirements for social and political accountability, for the public good, and for democracy. Safe and effective algorithmic systems, transparency, explainability, researcher and regulator data access, data privacy, protection from algorithmic bias and discrimination, the provision of other possible options like opting out, and more. Among these, what I just named or enumerated were some of the principles of the Blueprint for an AI Bill of Rights, which I'm happy to talk about more, that was developed with colleagues in the Biden-Harris administration. So in closing, what I want to say is that, we will never have, as things stand, we don't have all of the data that we need to truly understand, but that we can understand the algorithmic world that's being developed with us and around us, and that our research journeys can return us again and again to the ongoing work of the transformation of the digital polycrisis to possible, if not inevitable, beneficial futures. Thank you. That's great.
So thank you so much for that, Alondra. Even the digital crisis was keeping me up at night, so the poly crisis now probably means no more sleeping for me. But I want to ask you about where you ended, the Blueprint for an AI Bill of Rights, which was one of your big projects, maybe your big project at the Office of Science and Technology Policy. Mm-hmm. My guess is that most people in this room know something about it, but it might be good just to start with, what is that document, and what were you or are you hoping to achieve with it?
Yeah. So let me just say a little bit about the Office of Science and Technology Policy and the parts of the executive branch which don't have rulemaking power, don't necessarily have regulatory power. What you do have is a kind of soft power that you can frame debates and frame issues. You can convene people. You can engage, legislators, folks in industry, people in the American public. So we came into office. I came into the Biden-Harris administration, and as a day one person. And I had been working on a book about OSTP. I was writing about the Obama OSTP. In particular, I was interested in the kind of large projects that they did there, the Precision Medicine Initiative, which were significantly these large data projects and investments and big bets. And a lot of that work in the subsequent administration sort of got dropped or didn't get carried forward, and didn't get carried forward, I think, in ways that people had hoped or anticipated. And so we came into OSTP, a new team. I think as those of you who are here who work in the policy space or in the legislative or legal space know, we've desperately needed data privacy legislation, other kinds of legislation for a very long time. People have been working hard to try to accomplish that for a very long time. But congressional polarization and gridlock is what it is. And so the question for us at OSTP in the tech policy space was, what could we do and offer, knowing that we have soft power, knowing that we can't legislate, knowing that we don't make rules, knowing that OSTP is not a regulatory agency, to the conversation. And moreover, is there a way that we could begin to engage larger swaths of the American public in the conversation? So in October 2021, we announced and wired that we're doing a year-long process to sort of create this blueprint for an AI Bill of Rights. And we start it begins with a bunch of roundtables. We have listening sessions. We had one of my favorites is we got introduced to an organization called Encode Justice, which is a national network of high school students who have lots of incredible opinions about facial recognition technology and surveillance, and in the way that young people are just so much more visionary and have sort of higher expectations for the future than we do. That was one of the more incredible experiences. And so that was the process. And then we talked to a bunch of stakeholders, industry, government, researchers, developed this document. There's 5 principles,
Can I just ask you about the process before you go into the document? One of the things we try to do at the Knight Institute is bring different disciplinary communities together to talk about problems that we're all tackling from different angles. And it's always a challenge because we don't usually have a shared vocabulary.
Yeah.
We're maybe talking about the same problems, but we're talking about the same problems in very different ways, or we think different things about those problems are significant. And I wonder, in this process of consultation before you drafted the document, did you find that there was enough of a shared vocabulary that people could meaningfully engage with one another?
No, I mean, some of the vocabulary was industry vocabulary. I mean, even think about the advanced AI stuff. What does alignment mean, right? Is it or Arvind's done such incredible work on the technical meanings of fairness, which are not necessarily sort of aligned with fairness as a normative value, for example. So I think that was really challenging. But I would also flag what you said about Arvind at the top is that he's a really good teacher, and so I think on the team. It's an incredible team of people at OSTP, and many of them are very good teachers. And so there wasn't a shared vocabulary, but they were able in engagements with stakeholder communities to be, to be able to create bridges if it wasn't the same kind of words or jargon or whatever. So a lot of the credit for I think the success of the consultation goes to teams. And then, a lot of it also is just I think people in government not speaking and just listening. So sometimes the consultation was just we did a kind of FDA strategy where people come, you get 2 minutes, and you can just speak your piece. And, we sort of just, and anybody could come, and, so often it was not sometimes it was trying to translate, but oftentimes it was just literally listening. For 2 hours, we're just going to listen to people in 2-minute intervals tell us what they think about facial recognition technology, surveillance capitalism, and the like. And so we created this document that had principles. We know well that particularly folks in this room, like industry's been creating principles. Everyone's got their principles, and we knew that was insufficient. And so the document also contains a lot of practices. We distilled best practices from industry and from academia. Things around auditing, risk assessment, but also actual things that were already being done in the federal government to use and expand regulatory powers to apply to automated systems in places like the Department of Labor, FTC, and the like.
And who did you imagine the audience would? I mean, who were you hoping to reach with the document? Yeah.
So the subtitle of the document is something like creating algorithmic systems that the American public deserves, or something. So that was our intended audience. It's very much written at the 8th grade or whatever, a reading level. It was not intended to be a technical document in any way. It was intended to be, in some ways, an educational document and a resource that people could come away learning something from about algorithmic systems and technical systems, but also why they matter, And so part of what we came to in the document is a definition of AI. I mean, we could have used the OECD definition, which is what is sometimes used in the government because the United States contributed to that. But we used a definition that was about automated systems broadly and about where they impact people's rights, opportunities, experiences, and so that where they really sort of the rubber hit the road for the experience of folks in the public.
Are you, were you, or are you happy with the way the document has been received? I mean, the document, as you know, as you alluded to, it's not binding. It doesn't purport to be binding. It's called a blueprint for a Bill of Rights,
right.
not a Bill of Rights.
Right.
But you must hope at some level that some pieces of it become part of the law.
Sure. Yeah. So, yes. I mean, I think I'll just speak for myself. I'm really happy with how it's been used. I mean, people are teaching it. Teaching at the Harvard Business School. They're teaching it. I got an email from an elementary school teacher earlier this week. So it's something that people can use and think through. Certainly it's been critiqued for. Not being binding, not being legislation, not being regulation. These are all, sometimes it's said as if it's not binding. It's just like, yes, we know. That was actually really, yes, we know that. And so, but I think there's California legislation now that's going through committee. It's been through initial committee that's based on it. That's AB 331, which is a law that Assemblymember Rebecca Bauer-Kahn is doing, which is exciting because there's a Democratic supermajority in California, so there's a good chance of success in that legislature. And California is the 5th largest economy, and if you can get some traction on rights-preserving automated systems in California, right. We can maybe get some traction in the United States.
Was there, this is an unfair question, but I'm going to ask you anyway. You don't have to name names, but I'm curious to know whether how the document was received within the government, because as you mentioned earlier, your power in this context is soft power. You don't have the ability to tell the Justice Department or tell the CIA. This is the way things are going to work. And I did notice at the beginning of the document, there's a long legal disclaimer, which I don't think you wrote, Alondra, that says, essentially that we recognize that these rights might apply differently in the context of, for example, national security. And that makes me wonder whether, I don't actually disagree with that point. The rights are going to apply differently in many contexts, right? Yeah. So, but it made me wonder whether there was some wariness in some parts of the government about this project, or some resistance to the project in some parts of the government.
Yeah, so I mean, it was a little bit of a weird project, right? Because it wasn't binding, because it wasn't legislation, because it was meant to sort of create some goalposts for executive branch's behavior. I mean, part of it, part of it is sort of the federal government, if you include DoD, is literally the world's largest employer, right? And it's one of the world's largest consumers, and so there's sort of first market mover power in the federal government around things like the procurement of vendor systems that use AI, for example. So we were thinking about that. So I think one thing to say about the document that people should know who haven't worked in government is that it wasn't like we just woke up one day and we're just got to page 73, we're done, press print, send it out. I mean, it went through months of clearance. And I mean, one of the things I love actually most about government, there's a sociologist named Francesca Paletta who taught here for a time and who has a book that's called Freedom is an Endless Meeting. So she writes about social movements, and she's just you want democracy, you just got to meet and meet and meet. And so government, I found as a person who, this is going into government for the first time, was just there's just everyone gets to weigh in. Yeah. So there was an extensive multi-agency kind of red line process. There was lots of meetings with your lawyer friends, with GCs and DOJ and all sorts of folks like that. But in the end, it was everyone there were a lot of trade-offs, lots. I think for civil policy, a kind of national security or IC intelligence community carve out, as always happens. So it's not particular to this particular document. And then some of so I'll say that. But it was getting any paper out of government people should know it takes a really long time. It's never just the whim of a couple of energetic people. I mean, it takes months.
Yeah, it's actually quite an amazing thing that you were able to get this out of the government in a relatively short period of time. And the document itself, I think, is very ambitious. Ambitious in the best sense of that word. And I think you probably had a choice between scaling back the ambition of the main document or adding a legal disclaimer that said we recognize that this isn't going to be the same everywhere. And I think you probably made the right decision. But I was just curious about that. You mentioned the possibility of legislation at the federal level. You also mentioned this possibility of legislation at the state level. I wonder whether you think there's a role for the courts here as well. I won't ask you about these specific cases, but as you know, the Supreme Court now has a bunch of cases where it's considering issues that relate quite directly to the to the problems that you were tackling in the blueprint, and that we're talking about at this at this symposium, including the Gonzalez case, which is really about whether platforms should be whether platforms can be held liable for their algorithmic amplification decisions, right? And I wonder whether what you see the court's role is in this in this context. Is there a role for the courts? Is it an important role? How do the courts fit in here?
Yeah. Yes. So I would say I'd start with saying a couple other things. There's also a Connecticut law that's implementing or intended to make the Bill of Rights, the AI Bill of Rights law as well. I think the role for the courts, I'm not a legal scholar, so is an interesting one in that a couple of things. I mean, to the extent that that courts are conservative, not in an ideological sense, but in a small c conservative sense, they, at their best, allow us to go back to sort of fundamental things around privacy, around First Amendment rights, and these sorts of things. And so, I guess my hope would be for the courts, and this is somewhat in the spirit of the blueprint and how we tried to think about the sort of fast-moving dynamics of new technologies and automated systems, is like, what are those kind of core principles that you go back to regardless of the context in which the case takes place? And so, so I think that's what's interesting about the Gonzalez case, even though that's a Section 230 case as well, right? Yeah. So I think that'll be interesting. But I think the courts are, with advanced AI, I mean, it's going to get really interesting because it's not, Ron Wyden recently has been, Senator Wyden has been said to, have heard to say in DC in recent weeks that he doesn't think Section 230, necessarily applies to generative AI, right? Like, it's not a hosting. It's not, so there's a lot of interpretation. I think that's going to need to happen with advanced AI, including obviously things that we're all reading in the press around, defamation and impersonation, and there's all of these sorts of things and liability questions. So I think it's going to be a really interesting time of legal interpretation.
We should let Arvind take over up here, but I want to ask you one last question. You mentioned possible models from Europe for some of these, some pieces of the regulatory puzzle here. Maybe we could, adopt or at least be inspired by models from other countries. And I guess I am interested to know to what extent you think the solutions here have to be local solutions. To what extent is the principles, the 5 principles that you invoke in the blueprint, for example, those are at a pretty high level, right, of abstraction. But when it comes to, should researchers get access to what kinds of data, you're much closer to the ground. And how important are local institutions that the background of the courts or the background of, the First Amendment in the United States, like, how much do you think those things will or should matter to the question of how AI or automated systems are regulated?
I think it'll be sort of both and, which is like what academics do, right? We're always in the gray area. Certainly, you mentioned First Amendment. I was thinking about civil rights, right? So there are ways that, those apply to the United States, kind of legal epistemology distinctively. And so even if you're dealing with, multinational big tech companies, that there are these kinds of local things that things that we'll have to deal with. But I think it's been you know, the tech policy space is really interesting because you're dealing with multinational organizations, but also at scale. And so it's been interesting to, you know, from my time in government, to observe the really earnest and hardworking efforts to try to get some sort of alignment, understanding that if there could be, you know, some sort of multinational cooperation around legal regimes, even if at the local level they have a different kind of granularity, that we can begin to get some traction on some of the problems around, you know, that algorithmic amplification and other kinds of algorithmic issues are creating. So I think both, and I think honestly, you know, the United States has, in some instances, I mean, depending on your perspective, so, you know, if you're an entrepreneur, maybe you don't think this, but certainly in kind of rights regimes and privacy regimes have sort of benefited from like almost bank shotting off of some of the legislation in the EU and other places, so.
Alondra,
what do you think?
What do I think?
You're the lawyer.
I have a very long answer to this question when it comes to the First Amendment.
Like a footnote in a law review article?
Yeah, exactly. Right. No, I mean, I think, you know, you must be right that it's both and, you know, but I think that there is this sense among some tech policy people that the First Amendment is a major obstacle to some of the things that most of us want to accomplish in this sphere. And we, you know, at the Knight Institute, we spend a lot of time thinking about to what extent the First Amendment should be an obstacle, whether the First Amendment is being appropriately interpreted by the courts right now. You know, this question of whether local institutions are, they're not a given, right? We get to decide what these things, what these things mean. And I think that there's a lot of value in a conversation with policy experts from other countries about, you know, why they have adopted the policies they have. And I don't think we should take it for granted that we can't do those things here if we think they're good ideas.
Yeah.
Alondra, always great to talk with you. Thank you so much for
Great
being
to
here.
talk to you.
Yeah.